Good day, sir. My name is Michael De Ocampo, and today we are going to talk about political law and what topics are on it. Let's get into it. First, let us know what is political law. Political law is a branch of public law which deals with the organization and operations of the government. Organs of the state defines the relations of the state with the inhabitants of its territory. First topic of political law is national territory. What is national territory? National territory means all the surface area, subsurface, water, and atmosphere comprising the territory of the country and its exclusive economic zone. Does the Philippines have its national territory? Yes, it does. The national territory comprises the Philippine archipelago, Luzon, Visayas, and Mindanao. With all the islands and water embraced therein, all other territories belonging to the Philippines are historic by right or legal title, including its territorial sea, airspace, subsoil, seabed, and other insular shelves and other submarine areas. Next, a trivia. Does national territory have an act or other name? Yes. RA 3046, otherwise also known as an act defining baseline of territorial sea of the Philippines as amended by RA 5446. It defines the baseline of the Philippine territory. I hope you learned something. Next is Mr. Macky.
Then we have the three branches of the government. The Philippine government takes place in an organized framework of a presidential, representative, and a democratic republic whereby the president is both the head of the state and the head of the government. This system revolves around three separate and sovereign yet interdependent branches, namely the legislative, which is the lawmaking body, the executive branch, which is the law enforcing body. We also have the judicial branch, which is the law interpreting body. Executive power is exercised by the government under the leadership of the president. The president has the power to veto or disapprove bills enacted by the Congress as per Article 6 of Section 27, as well as to set aside decisions of the court according to Article 7, Section 19. The legislative power, on the other hand, is vested both in the government and the two chambers of the Congress, which is the Senate and the House of Representatives. For the Congress, this governing body includes some of its powers, such as overriding the veto of the president according to Article 6, Section 27, number 1, and as well as to revoke the proclamation of martial law, which is according to Article 7, Section 18, as well as to impeach the president and the member of the Supreme Court. Lastly, we have the judicial power, which is vested in the courts, with the Supreme Court of the Philippines being the highest judicial body. Now, this governing body has the power to determine whether or not there has been a grave of abuse when it comes to the discretion amounting to lack of excess jurisdiction on the part of the Congress and the President as of Article 8, Section 2. Now, under the Executive Department, we have the President, the Vice President, and the Cabinet officials. For the Legislative, we have 24 senators, and we have 250 members under the House of the Representatives. Then, for the Judicial Branch, we have 1 Chief Justice and 14 Associate Justice, which totals to the number of 15. Now, under the principle of separation of powers, these three branches, the officers entrusted with each of these powers are not permitted to encroach upon the powers confided to the others. Now, if one department goes beyond the limits set by the Constitution, these acts will become null and void. The adoption of this principle was motivated by the belief that arbitrary rule would result if the same person or body were to exercise all the powers of the government.
Republic Act No. 9593, or also known as Tourism Act of 2009, was enacted on May 12 by President Gloria Macapagal Arroyo in Cebu City. The principal authors of the law are Senator Richard Gordon and former Bohol Representative Edgardo M. Chato. The state acknowledges tourism as an indispensable element of the national economy and an industry of national interest and importance. Tourism is now a major revenue generator, a catalyst for socio-economic growth, and a source of national pride. The main objective of the law is to strengthen the Department of Tourism, or DOT, and its attached agencies to efficiently and effectively implement tourism in the Philippines. So why do we need to implement tourism here in our country? The answer is simple. It's because tourism is one of the world's largest and fastest growing industries. It is also considered an industry that generates opportunities for employment of skilled workers since it is labor intensive. According to the United Nations World Tourism Organization in 2009, the tourism industry has experienced continued growth and diversification to become one of the largest and fastest growing economic sectors in the world.
According to the official gazette, the Department of Tourism, or DOT, is the primary planning, implementing, and regulatory government agency responsible in developing and promoting the Philippine tourism industry, both internationally and domestically. Currently, it is headed by Department Secretary Cristina Garcia Frasco. Promotion of the Philippines tourism industry is one of the focuses of the Department of Tourism. Throughout the years since their establishment, DOT has come up with various slogans to help in campaigning our country as a tourist destination. Two of those slogans are "Wow Philippines" and "It's more fun in the Philippines." The latter went on to become popularized and was well received. DOT has several attached agencies which are also known as the DOT family. Each of them has their own responsibilities to fulfill. To start with, Tourism Promotions Board, or TPB, is basically in charge of the marketing and promotion of the country as a tourist destination. Another attached agency of the Department of Tourism is the Intramuros Administration, or IA, which focuses on the restoration, administration, and development of Intramuros. Another is the National Parks Development Committee, or the NPDC, which manages specific parks in the country along with its development and preservation. Tourism Infrastructure and Enterprise Zone Authority, or TIEZA, is another attached agencies under DOT. Here, the implementation of policies and programs in relation to tourism projects, development, promotion, and supervision happens. Another attached agency is the Duty Free Philippines Corporation, or DFPC, which operates a merchandising system in the Philippines that is duty and tax-free. Nayong Filipino Foundation, or NPF, is a non-profit organization that is one of the attached agencies of the Department of Tourism. They not only develop projects in the humanities and social science field, but they are also tasked with establishing parks and recreation centers to promote the tourism in Philippines. Philippine Retirement Authority or PRA is another attached agency of the Department of Tourism. Here, they are responsible for promoting and developing the Philippines as a retirement place. The last attached agency of the Department of Tourism is the Philippine Commission on Sports Scuba Diving or PCSSD, which has responsibility over the proposals of plans and projects to help the country become a renowned diving destination in Asia.
Good day everyone, I am Aina Hasegawa and today I am going to discuss the overview of the Labor Code of the Philippines and the kinds of employment under the labor law. The Labor Code of the Philippines stands as the law governing employment practices and labor relations in the Philippines. It was enacted on Labor Day of 1974 by President Ferdinand Marcos in the exercise of his then extant legislative powers. It prescribes the rules for hiring and termination of private employees, the conditions of work including maximum work hours and overtime, employee benefits such as holiday pay, 13-month pay and retirement pay, and the guidelines in the organization and membership in labor unions as well as in collective bargaining. The Labor Code contains several provisions which are beneficial to labor. It prohibits termination from employment of private employees except for just or authorized causes as prescribed in Articles 282 to 284 of the Code. There are 5 different types of employment in the Philippines and they are determined by the nature and or existence of activities that an employee is required to perform. Regular or permanent employment is when an employee performs activities that are usually necessary or desirable in the usual business or trade of the employer. They enjoy the benefit of security of tenure provided by the Philippine Constitution and cannot be terminated for other causes than those provided by law and only after due process given to them. Under Article 281 of the Labor Code of the Philippines, the maximum length of probationary employee shall be 6 months and is counted from the date an employee started working. When the employment is not terminated after the 6-month probationary period, it shall then be considered as a regular employment. An employee under fixed employment, also known as contractual employment, is one who is engaged to perform a job, work, or service for a predetermined date of completion or whether the employee has a specific date of termination. During the term of the contract, the fixed-term employee in the Philippines cannot be terminated for causes other than those just and authorized causes provided by law and only after due process is given to them. Seasonal employment is when the work to be performed is only for a certain time or season of the year, and the employment is only for that duration. This type is common practice in retail, food and beverage, hospitality, and other related industry as an augmentation to their workforce to cover the demand during peak seasons. A common practice for some employers is to hire regular seasonal employees who are called to work during peak seasons such as Christmas season and are temporarily suspended during off-seasons. There is casual employment when an employee performs work that is not usually necessary or primarily related to the employer's business or trade. The definite period of employment should be made known to the employee at the time they started rendering service. If the employee has rendered service for at least 1 year in the same company, whether the casual employment is continuous or not, they shall be considered as a regular employee with respect to the activity they are employed in and will continue rendering service while such activity exists. Job contracting, legitimate job contracting, or subcontracting refers to an arrangement whereby a principal agrees to put out or farm out with the contractor or subcontractor the performance or completion of a specific job, work, or service within a definite or predetermined period, regardless of whether such job, work, or service is to be performed or completed within or outside the premises of the principal. Labor-only contracting, on the other hand, is defined under Article 106 of the Labor Code. It refers to an arrangement where the contractor, who does not have a substantial capital or investment in the form of tools, equipment, machinery, or work premises, among others, supplies workers to an employer, and the workers recruited are performing activities that are directly related to the principal business of such employer. Remember that job contracting is valid and recognized by law, while labor-only contracting is a prohibited act.